Hello, Cliff Stanwyck, Stanwyck Real Estate, and today we're going over a new listing agreement that sellers now have to use called the Residential Listing Agreement Seller Reserve. So I'm happy to discuss today a brand new residential listing agreement called Seller Reserve. It's an authorization and right to sell where if you as a seller find a buyer for the property, that you can basically not pay the listing broker commission. And that seems to be really good. That seems it would be awesome. You find the buyer, and the buyer is didn't contact your agent or knew that you were selling the property, or you did a social media post. Now you do not have to pay the listing broker. But let's talk about the three different types of listing agreements that someone in California can use to sell their property. So let's hop into it. The first agreement, which everyone normally sees, is the exclusive right to sell, which is a contractual agreement under which the listing broker acts as an agent or as a legally recognized non-agency representative of the seller, and the seller agrees to pay a commission to the listing broker regardless of whether the property is sold through the efforts of the listing broker, the seller, or anyone else. And a contractual agreement under which the listing broker acts as an agent or as a legally recognized non-agency representative of the seller, and the seller agrees to pay a commission to the listing broker regardless of whether the property is sold through the efforts of the listing broker, the seller, or anyone else, except that the seller may name one or more individuals or entities as exemptions in the listing agreement. And if the property is sold to any exempted individual or entity, the seller is not obligated to pay commission to the listing broker. So, long story short, if your house is listed and you're using this agreement, the exclusive authorization and right to sell, exclusive agency, when that house is sold, the broker will be paid the entire commission. And if there's another agent involved, they will get whatever the cooperating commission is. But at the end of the day, if someone buys your house and it was maybe from means that wasn't directly due to the efforts of the broker, you will be paying them. It could be a friend of a friend. It could be a college roommate told somebody about your house and they come out of the area and they buy it. You're paying the broker a full commission. So let's talk about the other type of agreement, which is the one we want to talk to today, and that is the seller reserved, or the exclusive agency listing, and it's known as the authorization and right to sell, which is a contractual agreement under which the listing broker acts as an agent or as a legally recognized non-agency representative of the seller, and the seller agrees to pay a commission to the listing broker if the property is sold through the efforts of any real estate broker. If the property is sold solely through the efforts of the seller is not obligated to pay a commission to the listing broker. So that's a very interesting statement. It's sold solely, and when we actually get into the residential listing agreement, it doesn't say sold solely, but it doesn't exactly do an awesome job of clarifying what that procuring cause or who brought the buyer to the deal. And there's a couple things it doesn't deal with, but let's just say if the seller finds a buyer, they do not have to pay the broker a commission or compensation in this case. So that seems like a great thing. On the surface, it looks pretty good. But then we have the last listing agreement, which is one you very rarely see, and that is the open listing. And you haven't seen the open listing. I just did a video on it. I'll post a link in the description on YouTube. It's basically a contractual agreement under which the listing broker acts as an agent or as a legally recognized non-agency representative of the sellers, and the sellers agree to pay a commission to the listing broker only if the property is sold through the effort of the listing broker. Now, this agreement, in my opinion, gives the seller the most flexibility to save commission, but I have a video on that. I'll link it again. But what we're here to talk about is the residential listing agreement seller reserve. And this is for cases where you want to be able to, not pay a commission if you are you sold the house. And it could be a host of things. It could be you found friends at work. You told friends at work. You did something on social media, on Instagram or Facebook or Reddit or Pinterest or whatever, right? And you now have a buyer, and you do not have to pay the broker compensation. But that sounds great, but it might be really problematic once we look at the contract. So let's look at the contract. So this is the residential listing agreement, and woohoo, it just got released. For over a year, we did not have this seller reserved listing agreement, and we did not have the open listing agreement. But now we have this seller reserved listing agreement, and this should allow you to, at least on appearance, save some commission. And I believe if you have a good working relationship with a real estate professional, you should be able to come to some understanding if you find a ready and willing buyer that there should be some way to work this out. So let's look at the agreement. Seems pretty straight up. Essentially, there's the listing price and terms, and here's the compensation, very similar to the exclusive agency. This is, you're going to put the total commission in here. You're going to basically do the cooperating commission down here. That this is the cooperating thing. So basically half the commission typically goes to the buyer's agent. And then essentially it talks about that the seller hereby irrevocably assigns to the broker the above compensation from seller's funds and proceeds and escrow. And so here's where the exemption is, that there's right here on this paragraph 3, F subparagraph 3, if the property is sold to anyone listed above during the time the seller is obligated to compensate another broker is not entitled to compensation under this agreement, and broker is not obligated to represent seller in such transaction. And then the next part, this is an exclusive agency listing. Seller reserves the right to sell the property directly to a purchaser without any obligation to pay compensation to broker unless otherwise specified in paragraph 3C or elsewhere in writing. So here's paragraph 3C, and this is where you would work out any sort of compensation that you may be willing to pay that broker if you bring a buyer. Now, again, what happens in this agreement, and it's fairly complicated, is that if you bring a buyer, you don't have any representations, right? Is not obligated to represent seller in such a transaction. So the broker isn't, and the listing agent isn't going to work for nothing. So you have to figure out a strategy to overcome this seller agrees to pay broker. It might be pretty simple. It might be you take the buyer's commission, that the cooperating part, and you remove it from the transaction. So you save 50% on the commission. That seems all fine and dandy until you find out that your buyer wants to be represented by an agent, okay? And then things get complicated, right? Because they could have gotten paid if they had contacted your broker directly rather than in you first. And now you have to make sure that that never happened, that there wasn't any inquiry from your friend. Like your friend called you up and said, yeah, my agent was looking on the MLS, and I wish I had known that your house was for sale. Well, the problem is that that gets back to this solely on your efforts, right? It's not solely on your efforts if the broker's involved. So this becomes really, really complicated. And I think the most important thing here is this agreement can work. I mean, it says it can work, but it's a challenging agreement to make work. Okay. And I don't see how you can really structure it, because the open listing basically says I'm only paying the buyer's agent on if they bring me a buyer, and then you're working out what you're going to pay the listing agent for possibly for getting the contract, the disclosures, and basically the transaction, because you already compensated them for the marketing piece, or you agreed to, but then you have a second part where you compensated them for if they didn't sell the property, right? That becomes super complex in this compensation agreement, again, because of this thing that that the seller warrants seller has no obligation to pay compensation to any other broker regarding the property unless the property is transferred to any of the following entities or individuals. So your best bet would have essentially given him a list of, anybody on my Facebook friends. That's one way to do it. People on Twitter, any people following me on Twitter. I mean, yeah, those are ways you could do it, right? But again, you still have this issue here with what do you do? Because now there's brokers not obligated to represent seller in such transaction. And it's complicated, right? The open listing, in my opinion, makes a lot more sense. But we're here to talk about the hope and the dream that you find a buyer, and basically you reserve the right to sell the property directly to a purchaser and without any obligation to pay compensation to broker. So again, what does that mean? Okay, what it really means that is if your buyer has a broker or an agent, and they bring them to you, you can still just say, you know what, we're done, we're down the road, and everything else. But now you're in a situation where you have to decide the dual agency, right? You're going to be working with that broker, and maybe you like your person, maybe he's very competent, maybe he's just not the marketer, she's not the marketer you think they should be, and maybe they're just not the agent that you think is worth 2.5%. I don't know, right? That's not the point. But the point is now you have to find an agent to complete this transaction. Either the listing broker needs to complete it because you really want to make sure you follow all the disclosure policies, or the buyer's agent, he needs to be willing to do dual agency. So it comes down to here is that you need to come up here to see and say, in addition, right? It's basically you would probably put it in the terms, the additional terms in here, or come up with an addendum. And the addendum would be not in addition, but essentially in the listing terms, you would address it there. You would sit there and say, if seller procures buyer, broker compensation to be a certain amount of percentage, right? Maybe it goes from 2.5 to 1% or 1.5%. But at the end of the day, what I'm trying to share with you with looking at the agreement here is that you would put any sort of terms of if you found a buyer in the listing terms, because you don't necessarily put it here because in addition, seller agrees to pay a broker. Well, it's not in addition, it's really an exception. So you put it in the listing terms. So that's kind of the first part of this thing is, there's some gymnastics, there's some stuff you have to figure out with the residential listing agreement, what happens. Because say you find a buyer and they have an agent, that's fine. You can enter into a single party compensation agreement, or he can offer one and you can decide to pay him, and then you can save money that way. Or you can figure out what you would do initially if you did find a buyer. And I think that's a good way to go, because it just clears things up that in case it does happen. Because it is problematic, if you do find this buyer, and how does this contract go forward? You have a listing agreement, but he's not going to represent you. So now you have a problem of, if once the representation is gone, is the listing now withdrawn or canceled? That could be, right? So these are things, again, that are complications in this listing agreement. So my best recommendation is to work out in the listing terms, what will happen if you find a buyer for your home, and what would the compensation be to them if they're represented by an agent, and if they're not represented by an agent, right? They may not have an agent, right? And they may be willing to do it. So those are kind of the things you have to noodle through here. But let's also look at the rest of this agreement, and I've covered this topic a lot. Again, you always want the MLS. It's the best way to get out. The public marketing of the property, paragraph 7, is the same. The MLS data on the internet is a good thing to understand. Your obligations as someone listing your house under seller representations are good. The obligation under broker and seller's duties, that's a really good thing to understand, especially in regards to if you want to hold off on presenting offers until a specific date. There is an option to do that. There is our view of the world that really you should not be looking at supplemental offer letters or buyer's letters. Basically, this is the pre-sales inspections and reports, which unfortunately in this area, I see way too many people not doing them. But again, this is so important for you to have all these reports. And as we get into the seller advisory, again, they'll review it, but it comes down to being structural, pest, general property, homeowners association docs, preliminary title report, roof inspection, pool inspection, septic, and sewer. And again, the seller needs to know that you're under the obligation to pay for all this stuff, so you're essentially, seller further agrees to indemnify, defend, and hold broker harmless from all claims, dispute, litigation, judgments, attorney fees, and costs arising from any incomplete or incorrect information supplied by seller, and from any material facts that the seller knows but fails to disclose, including dangerous or hidden conditions of property. So we talk about that, and that's because also that, essentially a lot of times these investigations come out. Now you have some material facts you have to disclose. We talk about the deposit. We talk about the agency representation relationships. We talk about some of the security, insurance showings, and audio and video. And again, this is a very important part of the photographs and internet advertising. And this is a kind of a boilerplate, but it's really important. Are you doing all the marketing that you could with the photography and the internet? We discussed the key box and the lock box. We discuss whether you have the authorization to put a lockbox. We talk about tenant-occupied properties. Again, this is a complication of the sale that is very much requires a full-time agent, and tenant-occupied property can be problematic. We talk about the sign. We talk about you agreeing to be in compliance with equal housing opportunity. And then we talk about attorney's fees. And then we talk about additional terms, like maybe you need a contingency to purchase a replacement property, right? And then if the sales real estate agent isn't a broker or it doesn't own the brokerage, we talk about management approval. We talk about successors and assigns. We talk about dispute mediation and how that works. We talk about the entire agreement, okay, which is that all prior discussions, negotiations, and agreements between the parties concerning the subject matter of this agreement are superseded by this agreement, which constitutes the entire contract and a complete and exclusive representation of their agreement and may not be contradicted by evidence of any prior agreement or contemporaneous oral agreement. If any provision of this agreement is held to be ineffective or invalid, the remaining provisions will nevertheless be given full force and effect. This agreement and any supplement, addendum, modification, included any photocopy or facsimile, may be executed in counterparts, meaning we can have a bunch of forms where we put them together and they show both people signed the document, but they don't necessarily means it's on one. And again, I'm not giving legal advice, we're not supposed to, but any questions you have with these forms, I encourage you to review with an attorney. We're not attorneys. We practice contract law without a law license. So here's the legally authorized signer. So this says basically, if you sign this thing, you are basically a legally authorized signer, right? And there's also things in here that say that even if you're signing it as a trustee or in some other capacity that isn't individual, that you will supply the documentation within 3 days of the execution of the agreement, okay? And, that's a piece there. So this talks about entity sellers, and essentially when you get done with this, that takes up to 6 pages. It's obviously shorter than the exclusive listing agreement, just a little bit. But here's the important part of this agreement, and I've covered this off on all my videos, is really this is the part that sellers really need to understand and why it's probably important, even though you have the right to, not pay the agent, the listing agent, if you find the buyer, right? An agent somewhere in this thing is probably going to be paid, because if your buyer doesn't have an agent, then they're probably going to want to use an agent. And you already have an agent with this listing agreement, but you've used an agreement that says you're not going to pay them if you procure the buyer. So again, it's really important that you resolve this situation of compensation to the listing agent if the buyer is unrepresented and is willing to engage in dual agency, or if the buyer does have an agent, what is the compensation that you as a seller are willing to pay for them so that you have representation, right? Again, if the agent does have, the buyer does have an agent and representation, you're not obligated to pay that listing agent or the listing brokerage. But again, you need to figure out what you're willing to pay them. And the bottom line is you've already signed a listing agreement to be represented. You could always yield your claim on commission and just close this thing with whatever the original listing agreement is, or you can figure out some way to negotiate it if it's primarily on your effort. Again, a lot of this would be just pretty much taken out of the equation if you had done an exemption in the listing agreement, but still gave yourself an option, right? It's complicated. I think the open listing agreement is a much easier way to go, but this is a way to save commission. So let's talk about why you need to have an agent. And it's in the seller advisory, right? In the seller advisory, this is where we traumatize you. We say selling property in California is a process that involves many steps from start to finish. It could take anywhere from a few weeks to many months, depending upon the condition of your property, local market conditions, and other factors. You have already taken an important first step by listing your property for sale with a licensed real estate broker. Your broker will help you, guide you through the process, and may refer you to other professionals. We should always refer you to professionals as needed. This shouldn't be as needed. This advisory addresses many things you may need to think about and do as you market your property. Some of these things are requirements imposed upon you either by law or by listing or sales contract. Yes, in the sales contract, there's this thing called an SPQ, but it's not in this advisory. So yeah, it's important that you have somebody that really knows the ins and outs of the contract. Others are simply practical matters that may arise during the process. Please read this document carefully. If you have any questions, Ask your broker, and this should be in bold type, or appropriate legal or tax advisor for help. Selling a home is complicated, right? And you hope in this process that you really have someone who's in your corner, who's going to be able to point you in the right direction, to give you solid advice, and to facilitate what we call a transfer of real, of real property. And that's what real estate is. But again, the seller advisory, which shockers at the end of the agreement after you've signed the listing agreement, is probably the most pivotal foundational document in the sale of your house. So let's just keep going. Disclosures. The general disclosure duties. You must affirmly disclose to the buyer in writing all known facts that are materially affect the value or desirability of your property. Side note, I don't know what the definition of desirability is, but it's probably everything, right? You don't know what it is. It could be green lawn, all right? You may want to disclose that the sprinklers don't work or are intermittent rather than they're working. You must disclose these facts whether or not asked about such matters by the buyer, any broker, or anyone else. The duty to disclose applies even if the buyer agrees to purchase your property in its present condition without requiring you to make any repairs. If you do not know what or how to disclose, you should consult a real estate attorney in California of your choosing. Broker cannot advise you on the legal sufficiency of any disclosure you make. If the property you are selling is a residence with 1 to 4 units for certain subdivisions, your broker also has a duty to conduct a reasonably competent and diligent visual inspection of the accessible areas and to disclose to the buyer all adverse material facts that the inspection reviews. If your broker discovers something that could indicate a problem, your broker must advise the buyer. So here's another problem, right? Another problem with this seller reserved document, right? If you find a buyer and you don't have anything in writing, your listing broker is no longer going to be doing this very important visual inspection, which is problematic because it's part of this agreement. But once the agreement is somewhat, convoluted, or I should say broken by you finding a buyer, then certain things go away, right? So this again gets back to the importance of, if you did your pre-sale inspections, which we're going to talk about, and you'll find out they're in the seller advisory, then some of these agent inspection issues that, kind of go away because you have a home inspection or a roof inspection or a pest inspection, right? So we're going to hop back in it. Here's this seller advisory. Now we're talking about statutory duties, right? You must prepare and deliver to the buyer, among other things, a real estate transfer disclosure statement, known in the business as a TDS, and a natural hazard disclosure statement, known as an NHD. You have a legal obligation to fill out the TDS form in its entirety, honestly and completely. All right. Many local entities or organizations have their own supplement to the TDS so that you may be asked to complete. Again, it's kind of important that you keep that listing agent, somewhat engaged in this thing, because say the buyer is an out-of-area person, it's somebody from San Jose, and they don't know there's a property inspection sale report like in the city of Davis that needs to happen. Okay, so again, it's kind of important that you understand these statutory duties, and you also have a real estate agent when they're listing your house that gets this stuff as well, right? So if your property is in a high or very high fire zone, you will have to complete the TDS and will be responsible for disclosing compliance with defensible space laws, and depending on the property's age, may also have to disclose if the building itself has been hardened to protect it from catching fire. So again, that's a big piece of selling your house now, this defensible space thing. And again, it's critical that you have an agent that's going to get you through that process, because there is costs associated for that, and it's going to impact a lot of things like the insurance for the property and the desirability of the property, knowing that there's a whole bunch of cleanup that needs to happen, right? So now we get into section 2. So there's also some booklets, and requires basically the homeowner's guide to earthquake safety, Commercial Property Owner's Guide to Earthquake Safety, Protect Your Family from Lead in Your Home, and Environmental Hazards, a guide for homeowners and buyers. So again, there's a bunch of booklets that need to be given to the buyer, given on the age of the property. And again, your listing agent should provide those to you. But again, if you give up your listing agent because you brought a buyer, who's going to make sure that you get all these documents, right? And so that's, in a nutshell, some of the challenges of selling your house. But, if you do spend the time to read this agreement and to look everything, the roadmap for selling your house is all there. All the instructions are there. It's in the paperwork. It's in the listing agreement. It's in the seller advisory. It's all there. And the disclosure. So it's really important that when you're talking to an agent that you do complete these disclosures prior to listing your house. Because again, if you find a buyer, your listing agent is out. So what happens? You do not want to be trying to figure out the disclosures when you found a buyer, right? So just pointing out here, a real big tip here is to get the disclosures done and getting back into the agreement, right? So basically, there is a NHD report which will cover off a lot of the NHD statement. I recommend that you get a natural hazard disclosure report. It makes a lot of sense. So getting back to paragraph 4 in paragraph A, or I should say B4, in this thing, if the TDS NHD lead, fire hardening, defensible space, military ordnance, commercial zone, or special tax disclosures are provided to the buyer after you accepted the buyer's offer, the buyer will have 3 days after delivery or 5 days if mailed to terminate the offer, which is why it is extremely important to complete these disclosures as soon as possible. The real gem here is that you should be completing all the disclosures to sell your house before you sell. You should be buying a natural hazard disclosure report is what you should be doing. You should have all this stuff online available to any buyer or buyer's agent for them to get to it. And there's platforms for that. So again, you shouldn't get hung up on it, but it's really key that you address disclosure when you put your house on the market. So the other things to talk about is we mentioned about deaf and other disclosure. Basically, it tells you what your duty of disclosure is. A big thing is that if you're in an HOA or a common interest subdivision, yeah, like I said, a condominium townhouse or property in a common interest subdivision, you must provide the buyer copies of the governing documents and the most recent financial statements distributed or other documents required by law. If you do not have a current version of these documents, you can request them from the management of your homeowners association. To avoid delays, you are encouraged to obtain these documents as soon as possible, even if you have not yet entered into a purchase agreement to sell your property. So it's one of those things, right, that I see way too often here, especially in Placer County, where you haven't done the disclosures, you haven't done the inspections and reports, and you wonder why the transaction doesn't go smooth or why there's all this drama and stuff to be negotiated or worked through. Make it easy on yourself. Really get this stuff done and have it all ready for the time you go out on market. I know that a lot of people don't see the value in the real estate agent that does that. You need to make sure that you have your house properly marketed and ready to sell, and having all the disclosures, pre-sale inspections, and just awesome online marketing is all part of selling your house. So let's hop back in here. We're talking about contract terms and legal requirements. So we talk about a buyer may request as part of the contract to sell your property that you pay for repairs to the property and other terms. Your decision on whether or not to comply with buyer's request may affect your ability to sell your property at a specific price. So we're talking about requests for repairs, which again, one of the pieces of this is you should be looking at the purchase agreement too. I do have a video on that on YouTube. Withholding taxes. There's certain indications that you may have to have taxes withheld, and you need to understand that, and you probably need to understand your exemptions from withholding taxes. And those are best handled with your tax advisor. Your real estate agent can give you some basic guidelines, but you really need to talk about withholding taxes. Again, we reiterate the prohibition against discrimination, discriminatory conduct in the sale and real property against individuals belonging to legally protected classes is a violation of law. Government required repairs, replacements, and alterations. This goes through the part of that you more often than not are going to have to install operable smoke alarms and brace water heaters, and provide a buyer with a statement of compliance. Existing operable smoke alarms that meet compliance standards when installed do not have to be removed, even if they're not up to current legal requirements. But again, there's also carbon monoxide detectors that are required in certain areas. And then some cities and county governments may impose additional requirements. So again, that listing agent, it's really important that you know your responsibilities for selling your house. And they're obligated to tell you those responsibilities because they're your agent. So another thing, the EPA lead-based paint renovation, repair, and painting rule program. This is something that is happened in 2010, and this also talks about that. So let's talk about the last part of this, and that is the marketing considerations. And again, this is all solid, super solid advice on selling your home, pre-sales inspections and considerations. You should consider doing what you can to prepare your property for sale, such as correcting any defects or other problems, making cosmetic improvements, and staging. Most people are not aware of defects or problems with their own property. One way to make yourself aware is obtain professional inspections prior to sale. Pre-sale inspections may include a general property inspection, inspection for wood destroying pests and organisms, a structural pest control report, and an inspection of the septic or well system, if any, among others. I would add a roof inspection, a sewer line inspection, a pool inspection, and a well inspection. It said septic or wells, but you should do every inspection you can to sell your house. And that way, you then have the opportunity to make repairs before your property is sold, which may enhance its marketability. It'll definitely enhance your marketability. Keep in mind, however, that any problems revealed by such inspection reports or repairs that have been made should be disclosed to the buyer. See disclosures in paragraph 2 above. This is true even if the buyer gets their own inspections covering the same area. Obtaining inspection reports may also assist you during the contract negotiations with the buyer. For example, if the structural pest control has a primary and secondary recommendation for clearance, you may want to specify in the purchase agreement those recommendations, if any, you're going to pay, like you're going to pay for a Section 1 pest clearance. Post-sale protections, that's where we talk about a home warranty. The other thing we talk about is safety precautions, which is basically, when your house is when you have your house for sale, you're strongly encouraged to maintain insurance and to take any and all possible precautions and safeguards to protect yourself, other occupants, visitors, your property, your belongings, including cash, jewelry, drugs, firearms, and other valuables located in the property, against injury, theft, loss, vandalism, damage, and others. So here's your California Privacy Act advisory, and that's pretty much the agreement. So let's try to wrap this up and basically tie it up. This agreement, the seller reserve, is a great opportunity for you to possibly sell your house, or if you sell your house, that you don't have to pay your broker any compensation. However, it's complicated. I think the open listing agreement does it much easier, and it's a more cleaner agreement if you're really determined to sell it to a friend or somebody you know from the get-go, okay? But this agreement is a benefit because in the normal exclusive agency and right to sell, unless you exempt those people in the beginning of the agreement, you are obligated to pay the broker for any sale that occurs during the listing agreement, no matter who makes it happen, right? So this is a way to save commission. It's a little complicated. And again, I'm here to help. If you want, you feel free to reach out to me to contact me about using the seller reserved listing agreement or the open listing agreement, or you can just let the agent do all the work, and that is the original exclusive agency and right to sell. So that's the end of this video. Again, you can reach out to me on Facebook at Cliff Stanwyck Real Estate, on YouTube, where this video will be posted, at Cliff Stanwyck Real Estate. And of course, you can go to my website, Stanwyck Real Estate, and contact me there. There's some great options for sellers to save on commission. I hope you get some insight about all your responsibilities and get some ideas of how to best sell your house. And I think we've done that today. Again, if I can help you, reach out to me. I wish you all the best in selling in this new market in 2023 with higher interest rates. There are plenty of buyers, but every seller, if they can save money, should try to achieve that. And I'm here to help. Have a great day.